We're going to speak today about cultivating a healthy and discrimination-free workplace, and we really thank you for joining us and hope you find that this is helpful. My name is Jillian Tuck-Katarna, and this is my colleague, Renata Antoniuk, and he Wright. And he was going to start by talking about age discrimination. Renata is going to speak to you about gender identity expression in the workplace, and then I'm going to talk about the duty to accommodate creed and religion. So really three distinct segments, but hopefully we'll find some useful themes.
Great. Well, thanks, Jillian. So going to speak about a recent case, the third one there, which just came out, I think, in July of this summer, but part of a number of cases that are emerging about the intersection between an older workforce and some of the benefits that are age based. But we'll give a little bit of context. First of all, so I think as we're all observing, there's increased work activity by seniors. So you can see here the trend over the last 40 years. In fact, the sort of seniors are retiring, more and more seniors are retiring down until about the mid-90s, and then it started to come back quite a bit. I haven't yet seen the stats from the household survey in 2021, but or the census in 2021, but that'll come out before too much longer. But you can see quite a significant increase in the proportion of seniors that's working at least part-time. It's basically doubled in the past 20 years, and certainly an increased activity during the pandemic. So if you kind of two points of measurement that I was able to obtain, you can see a significant increase that's continuing through the pandemic. So all of this then kind of brings up issues relating to the legal framework within which we all operate. First of all, we've also had the abolition of mandatory retirement, and so leading to more workers working past 65. Our human rights codes generally prohibit age discrimination, but there are exceptions for benefit plans and pension plans. Without getting into the details in Ontario, which takes a very complicated route to get to the same place, but basically you can deny benefits for those over age 65 because the definition of age excludes, it stops at 65, and you can also make age-related distinction based on an actuarial basis. So the Human Rights Code says, yes, for benefits plans, you can make these distinctions, but of course, we're all subject to the Canadian Charter of Rights and Freedoms, and that prohibits discrimination on the basis of age. So one of the central issues in this case was, does the Charter prohibit this Human Rights Code distinction? So let's look a little bit about the decision. The grievor was an active employee, and he died at age 66. So there were two issues. First, life insurance. At age 65, under the company's group life insurance policy, the amount that was payable reduced from 2 times earnings, and the decision didn't say what his earnings were, but reduced from 2 times earnings to $5,000. And then the second one is that his long-term disability coverage, he did have a period of disability previously, terminated at age 65, and so on that one the union filed a policy grievance saying that wasn't permitted. And so the question is, does the Charter override the age 65 benefit carve-out in the Human Rights Code? And these sorts of things are really, really common in workplaces. I see it all the time. So the collective agreement that the company was subject to said that you get 2 times earnings life insurance coverage, and there was no explicit wording in the collective agreement that reduced coverage for people that were under age 65. But the company, when it got its life insurance, had in place a life insurance policy that said when you turn 65, the benefit is reduced to $5,000. So the company had said one thing in the collective agreement, but then it went out and got a policy that said something else. The reduction had been in place for decades, and the collective agreement also required the employer to notify each employee of the amount of life insurance they had twice a year, which the employer hadn't been doing, and the employer relied on the insurance company booklets, which the evidence weren't distributed to the employees, and estoppel, which is because this had never happened before. So the arbitrator did not have a very positive view of the employer's position on this one. Basically, the arbitrator said you're stuck with the wording of the collective agreement. You can't claim estoppel because this is the only time anybody knows that this has happened, and estoppel, you require sort of a pattern of activity, and this is the only time anybody could think about in certainly several decades. And there was no evidence that the union was aware of the reduction at age 65, and I think even if they had been aware, to what extent would that have bound an individual employee? And the collective agreement wording was clear. There wasn't any limitation at age 65, which, from my own point, I would say there obviously could have been, because there was, as we'll see with the LTD policy. And so ultimately, what the court said is that or the arbitrator said, is that they're upholding the wording of the collective agreement. So the grievor, or in this case the grievor's estate, did receive life insurance of 2 times annual earnings, and the company would have been able to recover $5,000 from the life insurance company and would have paid the balance itself. And I do a lot of support for our M&A practice as well, and you'd be amazed how many times, as we're going through due diligence for a deal, I'm sort of asking for the life insurance policies, and I'm asking for the collective agreements, and I put them together and I say, look at this, the company is self-insured a certain proportion of life insurance benefits, because the life insurance reduces with age, but it doesn't say that all in the collective agreement or the employment agreements. So then we move on then to look at the LTD policy, and as I said, although the collective agreement did not explicitly reduce life insurance benefits at age 65, it did terminate LTD benefits at age 65. Again, as I mentioned at the outset, that's permitted by the Human Rights Act, the Employment Standards Act, and that's common across Canada. So now we've really engaged in the issue of, does the Charter, Section 15, the equality rights provision of the Charter, overrule this particular carve-out? So it's permitted under Ontario law with this carve-out, but is the carve-out removed, the effect of the carve-out removed due to the provision of the Charter? So unlike some of these cases that have come forward in recent years, the employer in this case did bring forward quite a bit of evidence, as did the union. So there was some evidence on ageism in the workplace and kind of how that operates. There was evidence that most employees, in fact, retire before age 65, but more are still working. I thought what was particularly significant for the employer in this case is they actually brought forward evidence about what kind of LTD insurance is available for people that are over age 65, and the answer is none. So there is very limited insurance. If one of the insurers, I think it was Sun Life, was willing to offer 2 years of disability coverage for people that were between age 65 and 70. So what that would mean is that if you were 65 and you became disabled or met the definition, you would get 2 years of benefits only, and then that would terminate. But nobody was willing to offer LTD coverage that went till 66 or 67. It all cut off at 65. Sun Life had this additional sort of add-on, and that was it. That was the only availability, and no conventional LTD for anybody over the age of 65. And the arbitrator also looked at, in this case, the interaction of the LTD plans and the availability of their pension plans. So in this case, more unusually these days, there was a defined benefit pension plan that was available, and that was structured on the basis of retirement at age 65 and some other benefit options. And so the employer was saying, and the arbitrator, I think, accepted that with the addition of Canada Pension and old age security, employees at age 65 often are better off on pension than they are if the LTD continued past age 65. So sort of taking a broader view of what's available. So then the arbitrator then moved into the analysis of the Charter. And the Charter says you can't discriminate on various grounds. One of them is age. That's part of the Section 15.1. The Supreme Court of Canada has a two-part test for discrimination. First of all, is there a distinction made on a prohibited ground? And clearly there is, which is age. I think a lot of times when we talk about discrimination, we just stop we think it's a one-part test. Is there a distinction on a prohibited ground? You can't distinguish on the basis of a prohibited ground, and you kind of stop on that basis. But the court has been clear that there are two parts to the test, and the second part is, does the distinction perpetuate prejudice or stereotyping? So, you know, if you're to say, look, you're old, so you wouldn't be able to work a full day because you're old, well, that obviously does perpetuate prejudice or stereotyping. But you've got to, you've got to clearly establish. You have to establish that there's been a distinction on a prohibited ground, and also that it perpetuates prejudice or stereotyping. So in this case, the decision I didn't find very clear. They just sort of said, look, clearly there's a violation of Section 15(1). I think if I'd been acting for the employer, I would have perhaps more vigorously argued that failing to offer somebody a benefit that does not exist in the marketplace is not a distinction that perpetuates prejudice or stereotyping. So you would say, sure, we've made a distinction on the basis of age, but the support for the distinction is that the benefit's simply not available when you're over 65, and so therefore that does not perpetuate prejudice or stereotyping. Whether that would be successful or not, I don't know, but it is a legitimate argument that could have been made and should have been made, but one that the arbitrator, if it was made, didn't come forward in the decision. Instead, the arbitrator just seemed to accept that there was a violation of Section 15, and then moved on to the what we sometimes call the saving provision of the charter, and which I'm covering only in the most summary of fashions. But basically, the idea is that, look, if there is a distinction or a violation of the charter in the equality rights provisions, is the limitation demonstrably justified in a free and democratic society? And ultimately, the arbitrator found that it was justified, and so therefore, overall, there's no violation. But it's interesting to kind of look at what the arbitrator said on the what the arbitrator looked at with respect to considering Section 1. First of all, they did note that the collective agreement specifically endorsed the conclusion of LTD, or the ending of LTD coverage at age 65, and talked about, therefore, freedom of association is a charter value, and so therefore, in effect, you have a competing charter value where the union and the employer have agreed that this would occur, and that this was a reasonable balancing of the interests and the benefits. Secondly, on the Section 1 analysis, they said, look, this limit of 65 coincides with the age when somebody would ordinarily receive an unreduced pension. They also looked at the impact on the workplace as a whole, because the cost of LTD coverage for those over 65 would affect the entire workforce, and so really, to a certain extent, there's a cost to the entire workforce, but there's not a cost to the individual employee, because that person has available pension income if the person wishes to take advantage of it. And that's often a lot of the trade-offs, and I think it's important with these cases is to look at the overall financial package. If you're going to extend life insurance to those over age 65, there's obviously a higher cost to insure people in their late 60s and early 70s for life insurance than there would be if you don't. So either the employer pays more, or alternatively, the employer pays the same amount, which then reduces the amount of the life insurance that's available to the group as a whole. And the same thing would apply to LTD coverage, although it's not available in the market. If it was available in the market, presumably the cost would be higher, so the employer is either going to be funding a higher amount for this benefit, or alternatively, the employer funds the same amount but reduces the amount of the benefit that's available for the group as a whole. So, really the key points to take away from this particular case is, I think, kind of get ready to begin with a lot more of these cases coming forward, as I think, we continue to face an aging workforce, and I think particularly with the demand for talent that we have, I think, be easier and easier for people who want to work and are able to work past 65 to continue to do that. Arbitrators love to enforce collective agreement provisions. That's what they're appointed to do. Nobody can criticize an arbitrator who insists on enforcing a collective agreement provision. And so you'll want to review to what extent is your collective agreement aligned with your insurance policy. There was one of the cases I mentioned, it was York University case the previous year with a fairly well-known fellow who passed away in his late 70s, James Laxer. And in that case, the same thing with York. The collective agreement provided that he continued to have insurance, life insurance, but their life insurance policy provided that the amount reduced significantly. I think probably down in that case to $50,000. So I think the amount that, or 5,000, I can't remember. But anyway, ultimately, I think York ended up having to pay over $500,000 because they had committed in the collective agreement that there would be life insurance, but they hadn't arranged their life insurance policy in a way that aligned with their collective agreement commitments. So the effect of that is that they're self-insured. So make sure you do look at that. In some cases, you may not care. Sometimes the collective agreement says the maximum life insurance policy is $50,000, and the policy that you would obtain from the insurer says that at age 65 it reduces to $5,000. So in that case, you're really underwriting $45,000, and given how many employees over 65 and how many of them may unfortunately die at work, it may not really, may not be worth the effort with the union, but it is a matter you should have, on which you should have some judgment. And then finally, I guess in looking at limiting your liability, you can see here that the distinction between the LTD and the life insurance. So with the LTD, what the company did is they put in place a distinction that first of all was in the collective agreement, but it also reflected the underlying industry realities. So to a certain extent, it wasn't the company's distinction, it was the life insurance company or the disability insurance providers distinction. So they were saying, look, we're really just carrying forward what the market reality is. And so I think the extent to which you can simply carry forward the market reality will be much more defensible. And as I say, it's always preferable to have the distinction in the collective agreement. So, any questions at this point? Yes.
Two quick ones. One, do you think in the life insurance one, if there had been some reference to the collective agreement that pointed towards the benefit booklet in any way as administering the benefit program or something that would have made a difference? Because there are many times when the actual benefit booklet or the policy kind of falls out of step with the limited things that are actually mentioned in the collective agreement. Like it doesn't contemplate everything.
Right.
So if there was something in the collective agreement that actually pointed towards this other document that actually oversees or governs this benefit program using that would make a difference in that decision.
Not in that case, because they had the amounts of the life insurance hardwired into the collective agreement. But certainly, if the collective agreement said that we'll provide life insurance in such amounts as are set out in the company's benefit policy from time to time, then it would really be the life insurance that would govern. No union, of course, is ever going to agree to the wording that I just suggested would be quite favorable, but you can, certainly the collective agreement can incorporate by reference other policies, and then you would look to those other policies to see what's there. So.
Second question.
Yeah.
Have you seen any challenges then to workers' comp? Because that's the other place where people are actually working. There's all sorts of restrictions that come up once you're 65. Or the fact that they don't pay for loss of wages or all these other things that you could then say are age discrimination compared to say some of these other places where people are not actually actively working.
I haven't. I don't know if any of my colleagues have. No. Yeah, but good news, we have this conference every year, so you can be You can be pretty sure that if not next year, then by the year after, we'll have one of those cases coming forward just with as our population continues to age. Oh, that tells me my time is up. But,
Thank you, Hugh. And I am going to be a little mindful for time, so I will ask just to hold your questions until the end. I will try to smoothly pivot from age discrimination to two newer protected grounds of discrimination: gender identity and gender expression. I'll talk about both broadly, and then I'm going to talk about two cases. One is from 2012, and I'll mention later why that year is so important. And one is more recent from 2021, Gallagher's Bar and Lounge. So we can all agree discrimination and harassment is bad. In Ontario, discrimination and harassment because of gender identity and gender expression is against the law. And this is set out in the Ontario Human Rights Code. It was included in there because there was a gap that of protections, essentially, where people who were transgendered, or if their gender identity or gender expression didn't align with their born sex, there was a gap of protection that was needed. And so 2012 is really important because that's actually when both of those grounds were added to the Ontario Human Rights Code. And 10 years ago seems like a long time, but when I look at precedents from the 1800s, it really isn't. And it's also difficult because gender identity and gender expression aren't actually defined in the Human Rights Code. So that's why, myself as a lawyer and everyone else that's working in employment, they really need these decisions to understand and get guidance as to what employer responsibilities are and how the Human Rights Tribunal will look at these cases. I know that some people in the room might actually operate in other jurisdictions as well, or at the federal level, so I will just mention that it was only in 2017 that gender identity or gender expression were recognized across Canada, so at the provincial and territorial level and also at the federal level. And there is the word "or" in there because not all of the human rights legislation includes protection for both. For example, Manitoba's code that only includes gender identity and not expression. We'll see what the future holds. So I won't put on too much legislation up here because that's usually when I lose people, but here is the two provisions that are related to employment. Section 5.1 in the code, as you can see, it prohibits discrimination in the employment context. It lists all the protected grounds. I have bolded gender identity and gender expression for you. Subsection 2 prevents harassment. And gender identity, I like to actually compare the two because gender identity is internal. It is how I identify. So it's each person's internal and individual experience of gender. It's their sense of being a woman, a man, somewhere in between on the gender spectrum. And I was born a woman and I identify as a woman. So that is my gender identity. It can be the same or different as someone's born sex, and it has nothing to do with sexual orientation. So if there's an individual who was born a female, but they identify as a man, and they're going to go down that transition path, even though they were born a female, their gender identity would be male. Gender expression, on the other hand, is the outward expression of your gender. And that's something that is easier to see. And it's essentially how a person decides to publicly show themselves to the colleagues, the world around them. It can include anything from their behavior, their mannerisms, the way they dress, makeup, and today I'm wearing a little bit of makeup. That's one of the ways I express myself. I'm wearing a dress. If there was a situation where a woman, she was born a woman and she identifies as a man, she might be wearing, a pantsuit, and she might be cutting her hair short. That's the way that she would be expressing herself outwardly to the outside world and to her colleagues. Generally, I would say it's mostly the third part that kind of comes up in our line of work where a person's chosen name and pronoun are also a way of expressing their gender, and that's when often employers have certain requests for them to acknowledge those pronouns. And this is a nice little infographic that I found that I think provides a good summary. So identity is how you personally identify yourself, and then expression is the outward expression of your gender. And this case, Vander Putin and Sadaco Packaging Corporation, it is actually one of if not the first, decision in Ontario after those two grounds were added to the Human Rights Code. So it provides employers with a lot of guidance as to their responsibility and obligations and how the tribunal has dealt with these matters. So in this situation, the applicant, as you can tell from the respondent's name, it was a packaging corporation, and the applicant began working for the respondent, a corporate respondent, initially as a man. And they were born a man, they were living a man. Generally, they were an okay employee. They had some interpersonal disputes, and eventually they ended up getting terminated. But fast forward a little bit of time, I think it was a year later, they got rehired by a different manager. And there's nothing problematic about the first termination. But during that time, they started to transition. And so when they returned, they had been registered at a gender identity clinic. They started dressing differently, started wearing makeup. They had changed their name. And they came to their employer. Because this was a packaging company, there was essentially a plant. And they had to come to work, change. So they asked for an accommodation if they could change in a different bathroom in comparison to everybody else. They wanted to be in the female bathroom. And it's interesting to note in this case that there's actually only like a single stall in the female bathroom. And the employer said, not until you prove that you're female. They were also subjected to various slurs, derogatory comments. They asked to be called by their preferred name, and they made various complaints about this to their employer. Their employer essentially ignored this. They didn't investigate it properly. They swept under the rug. When they did investigate it, sometimes they didn't interview the applicant. They interviewed the other people. So eventually there was an altercation at work, and the individual got terminated. And thus they brought this human rights claim. They alleged that they were subjected to harassment, a poison work environment, and eventually dismissed in violation of the Human Rights Code. The respondent did participate, and they denied all the allegations, but the tribunal essentially accepted the applicant's evidence and sided with the applicant. And it's interesting to note that in this situation, the tribunal noted that this was not a phenomenal employee. The employee had some anger issues. They asked inappropriate questions at work, but irrespective of that, everyone is still entitled to protection under the code. So the tribunal recognized that even this employee who doesn't have a perfect track record, they have the right to freedom from discrimination under the code, and that also imposes an obligation on the employer. So what that meant is that the employer, once these complaints are made, they have an obligation to reasonably investigate these complaints and address them in a timely manner. And because the employer didn't act and respond and investigate, the applicant was successful. And to the employer's credit, they did do some things where I think that they did put a policy in place, but the policy listed some grounds. They didn't put gender identity, gender expression in there, or anything that would have protected this employee specifically. And this is also a reason that these two grounds were included in the code, specifically for these gaps. So in this case, they provided a lot of useful guidance to employers. And this applies for gender identity and gender expression, as well as other protected grounds as well. Because if an employee comes up to you and they say that they feel that they're being discriminated against or that there's harassment, you have to ensure that you have some sort of policy or procedure in place that first reminds employees that certain conduct is not allowed. Second, that people, if they're going through it, they know that it's not allowed, and there's a procedure for them to feel confident and safe coming forward. There's also, it's not enough just to have these policies, you also have to follow them. And if there is an internal complaint, you have to think about whether or not the employer treated it seriously. So think about who's going to be investigating these matters. Are they qualified? Do they need training in order to identify it and know how to properly investigate this? Who are you interviewing? Are you keeping the employee up to date and involved in this process? And once you investigate, do you have a plan forward? Irrespective of your findings, you do need to ensure that your employees do feel safe. So this is good because it provides its kind of a framework for employers to consider to ensure that when these issues arise, they are responding to them appropriately and timely. The more recent case is from 2021, and as a disclaimer, I will say that this bar is no longer in operation, and the respondent did not respond. So, irrespective of the human rights issues, one takeaway is if you ever receive a human rights complaint, respond. Don't just ignore it, because once you ignore it, essentially all the allegations are accepted as true. So in this situation, as you can tell from the name, there was a bar, and there were 3 applicants. One that identified as queer, and 2 were non-binary. And when they got hired, they had conversations with the bar owner and the manager, and they all wanted to be using their personal pronouns as they, them. They did their job. There was no discipline. They were doing a good job. They generally were good employees. But their employer was not respectful and did not appreciate their requests for them to be referred to as they, them. They used a lot of slurs towards the customers in front of these employees that these employees overheard. And when they raised these considerations and the complaints to the employer did not take them seriously. So as you can anticipate, it led to a human rights application, and they were successful. The tribunal found that the employer did discriminate against the employees because of their gender identity, gender expression, and sex by exposing them to transphobic slurs and misgendering them by refusing to use their proper pronouns. And I think sometimes people get a little scared because they think, oh, if on one occasion I don't refer to somebody by their personal pronoun, or if it's an accident, is there going to be a human rights complaint? It requires something more than that. I don't want to say necessarily malice in each situation, but like one slip up is not going to be a human rights complaint. It requires something more. And what you really need to, well, I guess I'm jumping ahead, but when you have employer requirements and strategies, you have to take an individual approach to these specific situations when they come for accommodation, but you should also be thinking about what you can do to prevent these situations and to ensure that you have the proper procedures that are followed in place to address them. So I know everyone has policies and procedures, but ensure that they apply to these kind of situations as well. As I said, these 2 grounds of discrimination were only added 10 years ago. If you have a rusty policy from 20 years ago, you might want to take a look at it and see if it needs updating. Have anti-harassment and anti-discrimination policies, which everyone who works with Miller Thomson, I hope you guys do. Have an accommodation policy and procedure in place. Ensure that the people who are involved in the process know what they're doing. See if there's any gaps, whether or not people need training. Have an internal complaints procedure. Make sure your employees know about it. Make sure it's followed. Update it every now and then. Education and training for the people who are involved. If it's more of a workplace issue, perhaps you need to have education and training to the employees at large so that they know what behavior is acceptable and what behavior isn't. And have an ongoing monitoring and evaluation, which coming to sessions like this is great because you can become aware of these situations and flag them if you think that they are going to be of a concern. All right. Thank you.
Thanks. So I'm going to jump to a discussion of discrimination on the basis of creed under the Human Rights Code, which as we'll see in a minute, the Human Rights Code of Ontario protects creed rather than religion. And so I'm going to use as a case study vaccination policies, because the question we want to explore today is when can an employee rely on their belief system as a grounds for refusing to comply with a workplace policy, and vaccination policies lend themselves perfectly to that kind of inquiry. So I've just reproduced here the section from the Human Rights Code that Renata just showed you, but bolded a different section. There's the word creed amongst one of the protected grounds.
And age, too, I noticed.
Sorry, we'll go back. Thanks. There's age there as well.
There
I think there's
too,
a
yes.
theme.
So I wanted to, first of all, emphasize that that I'm talking about constructive discrimination. So where we're talking about discrimination on the basis of creed, we're not talking about an employee policy that says we don't hire Catholics here. That would be overt discrimination. We're talking about a policy that the effect of the policy results in discrimination. And that's prohibited except where the requirement that's included in the policy is reasonable and bona fide. So that's the area that we want to look at with respect to creed. And there is a section following that talks about the duty to accommodate to the point of undue hardship. Undue hardship, which takes into account cost, outside sources of funding, and health and safety requirements. So unlike some of the other sections of the code, like gender expression and identity, we do actually have something to work with when we're talking about the duty to accommodate. So what is creed? Well, the Supreme Court and many decision makers in Ontario have adopted not the Supreme Court of Canada, the Ontario Superior Court, and arbitrators in the Human Rights Tribunal of Ontario have adopted the Human Rights Commission's definition of creed. And so they have identified some characteristics which constitute a creed. So the Human Rights Commission directs us to think about whether or not a belief is sincerely, freely, and deeply held. Is it integrally linked to a person's self-definition and spiritual fulfillment? Is it a comprehensive, particularized, overarching system of belief that governs one's conduct and practices? Does it address these ultimate questions of human existence, like ideas about life, purpose, death, existence of or non-existence of a creator, and a higher or different order of existence? And is there a nexus or connection to the organization or community that professes a shared system of belief? So this is a helpful definition of creed because, as we saw with the arrival of COVID, and Renata and I do a lot of work in the education sector, we saw a lot of parents asserting that they didn't believe in masks for their children, and that was their creed, and nobody could make their child wear a mask in school. And so it's actually, the Human Rights Commission is saying, well, it's a bit more complicated than that. And so we look at these kinds of principles as saying this is a starting point. You can't just assert a belief not to do something and then be treated differently. And the Human Rights Commission has also given us some direction on what it's not. So they've said in response to COVID-19 policies and policy statements that they issued a policy statement saying that personal preferences and singular beliefs do not amount to a creed and are not entitled to protection under the code. And so those two definitions are helpful because I wanted to draw your attention to a decision of an arbitrator that looked at creed, and this was the case of the Public Health Sudbury and Districts versus Ontario Nurses Association. It was a recent decision, June of 2022. And this was an employee who requested an exemption from their employees' vaccination policy, which said that everybody in the workplace had to be vaccinated. And so effective September of 2021, the employer said all employees have to provide proof of vaccination or proof of a medical exemption or entitlement to an exemption otherwise required by the code. So typical of employer vaccination policies, and in this case, in the context of healthcare provision, so very fitting, and certainly something that we've seen courts have recognized throughout Ontario and other jurisdictions as being reasonable. So talking about that notion of reasonable and bona fide requirements, we have seen courts take judicial notice of certain facts related to COVID. They've taken judicial notice, in other words, recognized and accepted as fact without the need of further proof. They've said we accept that COVID is an easily transmissible and potentially deadly virus. They've taken judicial notice of the fact that vaccines are safe and have been effective, and that government directives and policies and public health statements have therefore allowed for employees to adopt policies which have imposed restrictions on their workplace. Just as a note, I'm not sure we're still in the same place now with respect to whether or not a vaccination policy would be found this winter to be reasonable bona fide, but we're looking at case law now, which was based on decisions made with respect to an employee a year ago. So it may be different, and I didn't include a slide on it because I don't know any more than the rest of you do what this winter will look like and what will seem reasonable and bona fide in the winter of 22-23. There are news reports from today talking about numbers and what it's going to feel like. So we'll just leave that as a question mark and continue with our exploration of this case, because I think it really it worked its way through this issue of whether or not a creed could be relied upon as a grounds of exemption from an employer policy. So in this case, the griever was a public health nurse claiming exemption on the grounds of her belief system, and her request for exemption was denied, and so she was ultimately terminated. So she cited as grounds that she was a practicing Roman Catholic belonging to a Latin Mass community, which was an Orthodox Catholic community, and that her objection was that the vaccines that were being administered were developed using fetal cell lines grown in a lab which descended from cells from fetuses aborted in the 1970s and 80s. So she objected to the chronology, the history of the vaccine. And so it was in the very early stages of research and development that these fetal cell lines were used, but nevertheless, she could legitimately trace it back, and so that was her objection to receiving the vaccine. So it was worth noting, I thought, that the fetal cell lines were not used in the vaccines themselves, only in the research and development phase. So that was her objection, and the arbitrator looked at a number of things and noted through the evidence that was led by the employer a great many, 13 in fact, inconsistencies in her evidence. She, for example, had taken vaccines and medicines in the past which were developed using fetal cell lines without researching the links. So one of them was the measles vaccine. She had agreed that she might have taken ibuprofen, aspirin, Benadryl, Tums, all those things were developed in the same manner as the COVID vaccines. And when she was cross-examined, her knowledge of the scientific basis for her claim was pretty vague. She hadn't done a ton of research, she'd just done enough to know that there was a link. And she had actually refused to be vaccinated even before she learned of the fetal cell line use in the research and development phase of the vaccines. She agreed that she administered the COVID vaccine to other people as part of her job. And she said, you know, there's a difference between taking something for an illness, for example, ibuprofen, and then taking something that was preventative of a possible illness, and she elected to assert her right not to have the preventative. So she had included in her evidence a letter from her pastor saying that it wasn't church dogma in her faith to refuse, but the pastor noted that the griever, he understood that the griever sincerely believed in her reasons for refusal. And there was a public statement by the Pope saying that it was morally acceptable to take the vaccine, and healthcare, participating in healthcare is a moral obligation, particularly where your neighbors and coworkers are affected. But in the decision, the arbitrator relied very heavily on a decision of the Supreme Court of Canada from 2004 that looked at the Charter Protection of Freedom of Religion and said that not only the tenets of the religion are, which are objectively recognized, are protected. And it's not just the protection of what religious experts say is obligatory or fundamental to the belief system. It's a subjective test. So you have to look at what this person believes is part of their religious obligation. And similarly, we can't rely on on evidence which speaks to the beliefs of other adherents to your faith. That may be relevant, but it's not determinative. So not all Catholics have to be objecting to the vaccine in order for this person to personally believe that it was contrary to the tenets of her faith. So her subjectively held beliefs are protected as long as there's some connection between those beliefs and the overarching system of beliefs that constitute her religion or creed. So the Supreme Court recognized that religious beliefs are fluid, and that's why evidence that this person had taken the measles vaccine 10 years earlier or allowed her children to be vaccinated using vaccines that were developed using these fetal cell lines was not determinative. They weren't prohibited from raising it, but the court said what she believed 10 years ago doesn't necessarily define what she's entitled to believe today. So this was somewhat problematic because she only formulated this belief after she'd already sort of publicly stated her objection to the vaccine anyway, but then it became tied to her religion subsequent, mid-COVID. Anyway, the court has said that vacillation in terms of your subjectively held beliefs is allowable, and the decision maker has to focus on what you believe at the time. And the court has said the state should not become the arbiter of religious dogma. So while the courts are qualified to inquire into the sincerity of a claimant's belief, because that's a finding of fact, they can base it on their decision on the credibility of the person, they're not to wade into what's the legitimacy of the religion in general. And in this case, the griever, notwithstanding all of the inconsistencies that were identified and discussed, found that this griever sincerely believed. It was sincerely her subjectively held belief that, that her creed legitimately prohibited her from accepting the vaccine. Looking at the fact that the Latin Mass condemns abortion, and there was a connection, albeit remote, because this was like how many generations later in the lab from the 1970s, there was a connection between the fetal cell lines and the COVID vaccine. So there was some basis for her belief system. And as I think Renata spoke about, it doesn't need to be the only reason for your objection, your creed. It can be one of the reasons. And as long as it's one of the reasons and it's legitimately, subjectively held, then that's something that the arbitrator was prepared to rely on and find that this person could refuse to accept the vaccine. So ultimately, we have a statement from the Supreme Court that says religious belief is intensely personal and can easily vary from one individual to another, requiring proof of the established practices of a religion to gauge the sincerity of belief diminishes the very freedom that we seek to protect. So the dismissal was not upheld, and the remedy was the matter was remitted to the parties to work out what should help, what should follow. The employee was reinstated. I think what's interesting to consider about, and this came up, I'm sure for many of you who are looking at masking requirements in the workplace during COVID, that if you have a reason why you can't wear a mask, let's say you have respiratory illness, it doesn't mean that you don't have to undertake any measures for COVID protections. It means that there's a duty to engage in the accommodation process to explore what you can do. So in the school context, we saw parents assert that their children couldn't wear masks due to anxiety, but maybe the accommodation was that they had to learn behind a plexiglass barrier. And if that's the alternative, suddenly some of the firmly held beliefs weren't so firmly held, or the medical condition that might lead a person to say a mask can't be worn. Parents were perhaps more willing to discuss that. So it doesn't mean no accommodation. There's just a duty on the employee to engage in the process and discuss what can be done. So I don't know what happened to this employee. She was working in a public health context. She wasn't vaccinated. She was one of 3 out of hundreds of employees that didn't get vaccinated. And so presumably she and the employer had to work out what she could do, and maybe the accommodation was that she didn't work around people who came to be vaccinated at clinics. So I just wanted to briefly, in the time that we have left, look at a couple of other cases which help us more fully understand some of these concepts. There was another case where somebody asserted that the vaccination policy of a fitness, Planet Fitness, a gym, was contrary to their rights under the Human Rights Code, and they cited the Catholic Church's concerns with fetal cells. But the person didn't provide any evidence that they were actually Catholic, so that didn't go very well for them, because the Human Rights Tribunal said, what else you got? And they said, well, I really object to vaccines on the basis of personal freedom and so on, and I just don't agree with it, and you can't make me. And so that's what took us back to this statement by the Human Rights Commission, where they said, your personal objection to something doesn't qualify as a creed. You have to meet these other criteria, like be part of an organization and so on. So this was a bit of a clumsy attempt, I think, to simply assert a belief in personal autonomy, and without more, that wasn't found to be part of an overarching systemic belief system. And one other decision I wanted to just draw your attention to, because I thought it was interesting in terms of how these matters proceed. This case involving the Salvation Army and QP, there was a griever who alleged that the policy discriminated against their belief system according to their faith, and they believed in holistic healing and prayer, and so it was an interim decision around disclosure, because the employer had said, well, we need to explore whether or not this does constitute your creed and meets the criteria that we're working with from the Human Rights Commission, and so we need all your medical records. And so the interim decision, as you might guess, is that the the arbitrator said, the decision maker said the employer can't go on a fishing expedition and ask for way more background and health records than they actually need. Not all the health records are relevant, particularly when we consider that the Supreme Court has said it's not your belief system forever that never changes, but rather your belief system at the time that you're seeking the exemption. So the union was ordered to produce the employer was ordered to produce time-limited records. So vaccination records going back to 2017, health records 1 year prior to the pandemic. Health records from the dentist were allowed because I think the employer was looking for evidence that the employee had accepted analgesics, which had the same history as the COVID vaccine. So that's helpful for employers to think about when you're conducting an investigation or pursuing a claim for exemption, because you want to make a reasonable request for fact-finding. You're going to make a contextual analysis, an individual analysis, as Renata spoke of earlier, and to that you're allowed to require that people produce something for you to go on, but you can't overreach in your search. So we find as takeaways that there's a significant deference to subjective beliefs of employees requesting accommodation on this grounds, and that personal values, assertion of your belief in freedom, the right to choose, is not a creed. There's consideration of a claim for a religious exemption always requires an individual analysis, and employers can request sufficient information to establish an employee's belief system is a creed, but not more, and limit your scope of inquiry to what's arguably relevant. And the reason we use that term is because that's the standard of disclosure that we face as lawyers. If you're involved in any kind of litigation, we have to ask you for all documents which are arguably relevant. So that's what you can be looking for as well, looking for some connection between the information or documentation you're requesting and the claim that's being made. And your employees have a duty to participate in that process. It's not enough simply to make a statement that you believe you don't have to, or that you don't believe in vaccines, or you don't believe in masks. You have to engage in a process that is fair to the employer as well. So those are my comments, and we have a few minutes left, and happy to take any questions. Yeah. The case I just did in the Salvation Army case hasn't been heard yet. So what I was showing you was an interim decision just based on the discussion around what had to be disclosed. But the previous decision was actually based on human rights ground, even though the decision maker was an arbitrator in a labor relations context. So I'm not aware of any cases that have gone that deeply into the issue, and I chose that case just because it was such a nice analysis of the position of the Supreme Court, and it pivoted from there to applying it to a labor relations context. Yeah.
Is it not now a vaccine that's not derived from the Nova vaccine? I think it's derived from a mark or something like that. Could they force an employee now who says, I'm not going to take that vaccine, but you could use it as an alternative vaccine if you take it that's not based on that? You could force them to take that vaccine?
Potentially, yes, and based on these, if your objection to it was creed, you'd have to tie that in, using all of the same principles we've just discussed, you'd have to tie your objection on the basis of creed to the history and the integrity of that vaccine. So, yeah.
I don't know for sure, but like the origins of Johnson & Johnson, but I'm sure everyone in their family has people in that kind of situation. And my cousin, he got Johnson & Johnson, and I think that the government actually brought in a specific amount for people who had these kind of concerns to try to encourage them.
Now, what do you think about the, it's just interesting about, they'd asked for the dental records to see if the person had taken any pain relief, for lack of a better description. But how would you, Jillian, would you reconcile that with the, with the Supreme Court of Canada saying, well, your values may vary from time to time? Because it seems to me the answer is just that, well, yeah, but when I got dental pain relief, I had different values then than I do now.
When I'm in a lot of pain?
Now, as I've evolved and I've become older, I'm much more devout than I was in my reckless youth when I was...
And less pain tolerant. I think it's interesting that I think you'd have to make this case-by-case factual analysis and ask the person. I mean, I don't know how long ago they received that kind of dental treatment. Was it 6 months ago? Was it after they'd already claimed?
If it was 6 months ago, I have fast evolving religious
light bulb
beliefs.
I think that the arbitrator in that case was very generous in terms of the inconsistencies, and ultimately found that he couldn't get past the Supreme Court of Canada direction, that it's subjectively held, it's fluid, you're allowed to change your mind, and you're not tied to what your religious leaders are directing you is allowable. You can take that as your starting point, and you can move towards verifying that your subjective belief at the time you objected was that you couldn't do it. And so the dental records were also limited to the recent time period. But I thought that was an interesting inquiry because, and creative actually, to think of that. So, okay, you took a measles vaccine 10 years ago, but you've evolved that. You can sort of follow that train of thought. But 6 months ago, you had a cavity filled and you felt okay. I don't know. I think it's fact-based, and maybe I think where, even though the court said some vacillation is allowed, not every 3 months, like you can't change all the time.
I have a question about the religious beliefs and the proof that the employee has to present. You mentioned the letter from the pastor. Is there any additional proof that they had to present in this case and maybe other cases in terms of request for religious discrimination?
Well, we talked about it.
Another part is, what would you consider in court as a request for religious?
Did you want to respond? Oh, sorry, I thought you raised your hand. So it was interesting in this case that the letter from the pastor said, this isn't a demand of our faith community, but I've spent time with this person, and it's my opinion that this is a firmly held belief. So that would suggest that you could bring other, for lack of a better term, character references. But that's not really what I'm meaning to say. It's more like affidavits or statements from people who could say that they've observed you to follow this observation.
Like affidavits of credibility almost, right?
And or I've seen, I was with this person when they went into the drugstore and asked about, the history of the drugs they might buy over the counter. I don't know.
But I think we can say that if you're going to assert something as a dogma of the Catholic Church, it's helpful if you also identify as Catholic.
Right.
Because one of the cases, person just said this is the Catholic Church, but did not then also say that they're Catholic.
So in that case, a letter from your pastor or your priest saying they attend regularly would be helpful. If the challenge was you're not even Catholic, so some onus on the employee, I think, to support their claim, so I think you can ask the employee to help you understand how it is that they make that claim and help you understand why you may rest there and accept it. Yeah. I think there's two issues there. And one is, I think what you're describing is, could a person come forward and say, I really don't believe in this vaccine because of what I read and what it's leading me to worry about, and therefore I don't want it. And that would not qualify as a creed. So could you take that same set of facts and say you have an anxiety to the level of an anxiety disorder, and you've got so you're making a medical claim for exemption. And the Chief Medical Officer of Health in Ontario issued a directive that was really clear of what constituted medical grounds for being exempt, and it was a very narrow definition. And so I don't believe that kind of worry would constitute a medical exemption, and I think an employer could deny on that basis. I think that wouldn't get us to the nexus we were talking about. Like that's too remote, and so would not be evidence that. So you're saying if someone drank coffee, could you rely on that to say, well, you allowed that stimulant into your body, and therefore you should be able to also accept a vaccine? And in this case, it was the history of the vaccine that was the objection that presented the religious difficulty for this griever, and so it wasn't all things that affected her well-being. It was the way in which the vaccines had been developed. So it was their history, for lack of a better term, I guess. So I'm not sure. My answer would be no. I don't think those two things would be connected.
You wonder too on the some of the what I might call the business practicalities of this. Like if you're on, for medium-sized or reasonable large employer, like how much effort and money do you put into kind of adjudicating, if I can call it this one person? Like some people put a lot of effort in, which is why we end up with these decisions, but I would think, Jillian, probably quite a few just look for ways to quietly deal with the situation without, presumably with legal advice, but without sort of a contested proceeding. What have you seen in terms of the trade-offs that employers, your school boards or whoever, are having to make on these sorts of things?
I think I was surprised at the level to which people were committed to not complying with vaccine and masking policies. But then I didn't foresee the protests in Ottawa either. So I think the answer is that we're in an environment where people have very firmly held beliefs about these things. And they may not always be tied to a creed, but they are firmly held, and people are willing to go to great lengths to assert their rights, and therefore perhaps there's a higher onus on employers to respond accordingly.
When you look at this and you think about this whole concept of quality integrity, and I think you mentioned about the school boards with that whole conscious exemption for other vaccines other than COVID. Why COVID and why this vaccine? Like, is this going to start reaching to all vaccines?
The exemptions to other vaccines that are required to attend school also include a process. It's not just waving your hand and saying no thanks. It's so that I think we're in the same environment.
Yeah, the conscious exemption in the schools don't require any human rights. It's just a course that there's no actual qualifier to be able to get that exemption.
And certainly the argument was made during the pandemic but I think COVID was treated differently because of the sense of urgency. And I think there was a decision not by school boards, but by the Chief Medical Officer of Health and by the province that we were in an urgent emergency situation and it was going to be treated differently than any other disease.
Have you seen any challenge on the bodily integrity kind of, like I have the right to vote on my body?
Yeah, I think that's why the Human Rights Commission came out with that statement that it did, that's not a creed. So whatever else it may be, and you want to challenge on some other ground, but it's not a creed just to say you don't, I shouldn't say just, it's a very firmly held belief by people, but it's not part of an organized body of thought. Well, I don't see any other hands, so thank you all very much for joining us. I hope it was helpful.